Today, I'm going to be speaking a little about how we work with municipalities, best practices for electronic meetings, some real examples of open meeting decisions. The Ontario Ombudsman was created in 1975 as an independent and impartial officer of the Legislative Assembly of Ontario. Paul Dubé is our current Ombudsman. He was appointed by an all-party legislative committee. Paul was reappointed in April for a second term. The Ontario Ombudsman promotes fairness, accountability, and transparency in the public sector by investigating individual complaints and systemic issues and issuing reports and recommendations. The Ombudsman and the French Language Services Commissioner within the Ombudsman's office also have the authority to investigate issues on their own initiative. The Ombudsman's authority covers more than 1,000 public sector agencies and provincial government ministries, boards, and commissions. It also includes provincial jails, as well as universities, municipalities, and school boards. In May 2019, the areas of child protection and compliance with the French Language Services Act were added to the Ombudsman's jurisdiction. The Ombudsman has robust investigative powers, including the authority to summons witnesses and require disclosure of documents. As you may know, since 2008, anyone can file a complaint about closed municipal meetings. Our office is the default investigator for municipalities that haven't appointed their own. Currently, we are the investigator for about 257 municipalities in Ontario. We were tasked with more general oversight of municipalities in 2016. Remember that as an independent and impartial body, we do not advocate for complainants. In fiscal year 2020-2021, we received 2,281 complaints about municipalities. We have received 17,610 complaints about municipalities since our general oversight came into effect on January 1st, 2016. 98% of those have been closed. The vast majority were closed through informal resolution. On this slide are the top 5 categories of municipal complaints received in 2020-2021. Council and committees complaints involve disagreements with council decisions or elected officials' conduct. However, our focus is on administrative process and fairness, not the behavior of individuals. Most cases related to municipal housing were resolved by facilitating communication with local officials. Bylaw enforcement remains a significant source of municipal complaints, both from residents concerned that bylaws are not being enforced and from property owners who feel enforcement is too harsh. Infrastructure and planning zoning complaints can involve roads, trees, snow removal, land use, and drainage issues. We often work to resolve municipal issues for all concerned by sharing best practices. For example, the Ombudsman often advises municipalities to have clear policies regarding conduct of members of the public and trespass notices. In one recent case, we spoke with the mayor and staff at a municipality that barred a resident indefinitely from all municipal property and virtual council meetings. They agreed to adopt a respectful conduct policy that includes an appeal mechanism and a process for regular reviews of existing restrictions. In another case, we discovered that municipal staff who barred a man from emailing them were not familiar with their own community code of conduct. They rescinded the ban and sent the man a warning letter instead, explaining why his voluminous correspondence was unwelcome. As I mentioned earlier, our office tends to receive a fair number of complaints about bylaws. In 2020, we received 160 complaints about 4 municipalities that were permitting local mosques to broadcast the evening call to prayer during Ramadan. The municipalities permitted the broadcasts for a few minutes each day, despite local noise bylaws, as they have discretion to do. Our review found that the municipalities weighed the noise issue against the meaningful positive impact for members of the local Muslim community. One municipality even found noise levels during the call to prayer were no higher than passing vehicle traffic. The municipalities also openly communicated with the public about these decisions and received feedback to improve the process for similar decisions in future. In another case, a municipality issued refunds to a group of residents after we discovered that the fees they were charged for property inspections were not authorized in any bylaw, as required by the Municipal Act. We also addressed issues relating to French language services. In one case, a man who spotted an electronic traffic sign near a construction site in English only, contrary to his city's French language services bylaw, also complained to us after municipal staff told him that it was on private property. We confirmed that the sign was on city property and that staff should have referred the matter to their French language services office. As a result of our inquiries, the sign was replaced with a bilingual one, and staff were reminded about how to refer such complaints internally. Our office regularly assists individuals with housing issues at the municipal level. In one recent case, we helped a single mother and her 5 children, including one with complex special needs, who were living in a motel. The woman had been told she would not qualify for social housing unless she paid $3,500 in arrears from 15 years earlier. With our help, she reached a local housing manager who reviewed her situation and committed to finding a home for the family. Since 2018, all municipalities have been required to use an integrity commissioner to investigate complaints of violations of their codes of conduct. We receive many complaints about local integrity commissioners, but our role is not to redo their work or act as an appeal court for their decisions. The Ombudsman's review in such cases will consider whether the local integrity commissioner acted in accordance with relevant legislation, bylaws, and complaint protocols, considered the issues presented, followed a fair practice, obtained and considered relevant information, and provided sufficient reasons to support their decision based on the available evidence. Where problems are identified, the Ombudsman may share best practices with the Integrity Commissioner or make recommendations to the municipality to improve its processes in future. In reviewing a range of complaints in 2020-2021, we shared best practices with many municipalities regarding the Integrity Commissioner process. We are also developing new resources for municipalities and the public on this topic, similar to our existing materials on municipal codes of conduct and integrity commissioners. We often receive complaints about delays and lack of communication in integrity commissioner investigations. One man told us he heard nothing for 8 months after submitting a complaint. As a best practice, we advise municipalities to have clear timelines in their code of conduct complaint protocols while allowing integrity commissioners the discretion to extend them if necessary. In another case, we reminded an integrity commissioner to be mindful of the strict timelines under the Municipal Conflict of Interest Act after a woman complained that he had exceeded them in her case. In another case, a woman who felt the integrity commissioner had not addressed all of her complaints told us he never responded to her concerns. Another individual received no further communication from the integrity commissioner about her matter once she filed a lawsuit against her municipality. We spoke with these integrity commissioners to stress the importance of communicating the reasons for their decisions to complainants. As a best practice, municipalities' protocols should include communicating with the complainant when an investigation is closed, including because of related litigation. There are several units within the Ombudsman's office which deal with complaints. There is a French Language Services unit, which addresses complaints under the French Language Services Act, the Children and Youth unit, which addresses complaints about services provided by children's aid societies and residential licensees, and the Generalist unit, that addresses all other complaints within our authority. Each unit has an early resolutions and investigations team. There is also a special Ombudsman response team serving the general unit and a legal team that supports all units across the office and is the area responsible for conducting investigations of closed meeting complaints. In most cases, the first contact a complainant will have with our office is with an early resolution officer who will try to resolve their complaint. First, they will contact an individual who's made a complaint and conduct a detailed intake. Our intake calls are audio recorded and saved to our case management system, which also assists to ensure that we retain accurate and complete information. We carefully review the information, analyze it, and consult. We have a team-based approach. We also have the discretion not to investigate inappropriate circumstances. Many complaints are closed without even contacting the organization that's been complained about. Consistent with the fact that we're an office of last resort, many cases are resolved by referring individuals to internal complaint and appeal mechanisms. Sometimes, though, we have to make inquiries to obtain relevant facts and documents. Before making inquiries, we obtain consent and document it on the file. We follow a practice of speaking with individuals most directly involved in the matter. We don't rely on a single contact person. When we talk about resolving complaints, we mean resolving to our satisfaction. We are impartial. We spend quite a bit of time managing expectations of complainants. We can also assist municipalities in cases where the complainant is being unreasonable, frivolous, or vexatious. If they've gone through your complaint process and still do not stop, you can refer them to us for an impartial review. Investigators at our office carry out further research, make inquiries, obtain documents, conduct site visits, and interview witnesses. Like early resolution officers, investigators focus on resolving issues by various means, and we have a very good track record for this. Most cases are resolved without formal investigation through focused reviews. To date, in the municipal area, we've only conducted 6 formal investigations concerning municipal issues. That is, in addition to the many cases we investigate relating to closed meeting complaints. The office's high-profile systemic investigations are carried out by our Special Ombudsman Response Team, also known as SORT. It generally conducts large-scale investigations that can impact millions of Ontarians and have encouraged sweeping policy changes. All investigations, including those conducted by SORT, start with a formal written notice and a formal document request. Formal interviews are conducted. While we have the authority to conduct them under summons, the power is not typically used. Before issuing a report and recommendations, the public sector body under investigation has an opportunity to review and comment on the preliminary report. This is typical of all formal investigations conducted by our office. Apart from general municipal complaints, we also deal with complaints about closed municipal meetings. Last fiscal year, we received 94 complaints about closed municipal meetings. Our role with respect to closed meeting complaints is quite different from our role in dealing with general complaints, in that our focus isn't on resolving complaints, but rather on enforcing the open meeting rules set out in the Municipal Act. We look at the very narrow exceptions in the Act to determine if a meeting has been closed appropriately and make recommendations if it hasn't. We also try to identify and share best practices with municipalities whenever possible to improve transparency and compliance with the rules across the province. In most cases, municipalities want to comply with the rules, but make mistakes in doing so. And we share tools to help them do just that. I'd now like to get into the main topic of today's conversation, electronic and hybrid meetings. When I say electronic meetings, I'm referring to meetings held using technology, like a live stream, video conferencing software, or teleconferencing line. When I refer to hybrid meetings, I mean meetings where some participants join remotely using technology while others attend in person. This has been an extraordinary year and a half for municipalities with important changes to legislation. Most significantly, municipalities can now hold electronic meetings and close sessions electronically, and remote participants can count towards quorum. As we've seen, municipalities had to scramble to put in place new practices and with them new policies to ensure these virtual meetings were productive, effective, and open to the public, since the open meeting requirements didn't change. So, do the open meeting rules still apply to electronic and hybrid meetings? Yes, they do. In general, all meetings, including electronic meetings of a council, local board, or committee of either of them, must be open to the public, unless the subject fits within one of the 14 exceptions to the rule. This means that members of the public must be able to observe electronic meetings in progress. Otherwise, the meeting may be improperly closed. At the outset of the pandemic, some municipalities struggled to continue to hold meetings while still complying with the open meeting rules. For instance, the Ombudsman found that the Township of Bonfield violated the open meeting rules when it held meetings in May and June 2020 over Zoom, without broadcasting or otherwise making the meetings accessible to the public. The Ombudsman recognized that these were the first meetings held by the Township during the COVID-19 pandemic, but noted that the pandemic did not alter the open meeting requirements. This year, we've investigated many complaints about electronic meetings not being open and developed some best practices to guide municipalities as they navigate these new waters. We've created some tips, resources, and guides to help municipalities, and we are most proud of our digital Open Meetings Digest. You can search our decisions and interpretations on the digest for guidance on how the open meeting rules apply. When in doubt, feel free to give our office a call. While we can't give you legal advice, our staff often help municipal staff and council members to locate relevant resources, including on the digest. In order to hold electronic meetings, a municipality must first amend its procedure bylaw to permit that kind of participation, and specify whether closed meetings can also be held electronically. In a report about the Board of Management for the Greater Napanee Business Improvement Area, the Ombudsman found that the board held electronic meetings without first permitting those meetings in its procedure bylaw. In the case of the City of Richmond Hill, the city had amended its procedure bylaw to provide that it would broadcast its open meetings whenever possible, and that if a closed meeting was the only item on an agenda, the meeting did not have to be broadcast at all. The Ombudsman recommended the city update its bylaw to say that open electronic meetings must not proceed unless they are broadcast to the public. One of the first steps that is required if a municipality wants to hold electronic or hybrid meetings, and which many municipalities have likely already done at this point, is amending the procedure bylaw to allow for electronic participation. The amendments may make rules regarding the extent and manner of electronic participation at a meeting. For example, the method of electronic participation, such as a teleconference or virtual internet-based meetings. Another thing to consider is whether to allow electronic participation of council and staff during the closed sessions of a meeting. Your municipality can also choose if a member participating electronically counts towards quorum. Your rules of procedure may also have to be adapted to an electronic meeting format. Your municipality can choose to allow certain bodies like council and the committee of the whole to hold electronic meetings and not others like committees. Finally, you must provide for public notice of all meetings in your procedure bylaw. Public notice should include the date, the time, and how to access the live stream of the electronic meeting. Instructions should be clear and include the details, like a link if the meeting will be live streamed or held over video conferencing, or a phone number if held by teleconference. Our office has found that the practice of broadcasting municipal meetings live on the internet can satisfy the open meeting requirements of the Act, provided that the public has sufficient notice of the time and the means to access the meeting. It's important to provide the time, date, and link to start. Municipalities should ensure that live-streamed electronic meetings are hosted on a platform which is generally available to members of the public. The method that municipalities choose should be reliable and accessible. We see many municipalities using YouTube or Zoom, for example. If the public does not know when and where a meeting will take place, it is not actually open to the public. With electronic meetings, providing notice requires not just the date and time of the meeting, but also detailed instructions about how to access the live stream or teleconference. When the Township of Russell live streamed a meeting shortly after the new electronic meeting rules came into force, we received a complaint that its agenda did not contain a link to access the electronic meeting. In fact, it referred to the fact that the meeting would be electronic, but listed the township's address. The Ombudsman recognized that the township had taken steps to inform the public that the meeting would be electronic, including in a pop-up alert on its website, a dedicated COVID-19 webpage, and on a page about upcoming meetings. It was also posted on the township's Facebook page and on an electronic sign in front of the township office. A hyperlink to access the meeting was added to the website and Facebook immediately before the meeting. When we spoke with the municipality, staff committed to providing a link to the meetings on the agenda going forward. The website was updated to provide a link to future meetings and detailed instructions for how to access meeting webcasts. The township also made video tutorials for residents about how to use the meeting software and added these to its website. The Ombudsman in that case found no contravention of the rules and commended the township for taking steps to ensure public access to the meeting. As a best practice, and to prevent confusion, the Ombudsman recommended that municipalities provide clear instructions in the agenda or meeting notice indicating how members of the public can access a meeting that is being conducted electronically. In another case concerning the City of Richmond Hill, the Ombudsman found that the city had contravened the Act when it provided notice ahead of an electronic meeting, but failed to provide information about how the public could actually access that meeting. But what about hosting a closed session virtually? It can become very tricky on virtual platforms, especially as municipalities move from open session to closed session and back again. This doesn't mean that municipalities shouldn't hold closed meetings electronically, especially when public health is a concern. It just means that municipalities should consider how they will ensure the confidentiality of these closed meetings. For example, are there separate links provided for the open and closed sessions, with only council having access to the closed session link? Who is responsible for ensuring that the live broadcast does not capture any closed session discussions? Can a staff member be available to watch the broadcast to alert council if there are any issues? Resolutions to go into closed session must be passed in open session before a meeting can be closed to the public. For electronic meetings, this means that the resolution must be either live streamed or broadcast. Any council business conducted after the closed session must also be live streamed. We've dealt with many complaints about this issue. In one case, we dealt with a complaint about the city of Niagara Falls, which alleged that council illegally discussed the designation of the Niagara River as a protected wetland in closed session. We found that this topic fit within the exception for advice subject to solicitor-client privilege, since council received legal advice from the city solicitor about the potential designation. However, we also found that council's resolution to go in camera was not broadcast live. We recommended that the city ensure that the public is able to observe all open portions of electronic meetings, even if council's only item of business is the resolution to close the meeting. So even if closed meetings are justified, the proper procedures must be followed. In a case concerning the city of Richmond Hill, the Ombudsman found that the city contravened the open meeting rules on 2 occasions when it passed a resolution to go into closed session, but failed to provide the public any way to observe that portion of the meeting. The Ombudsman explained that the expedited publication of minutes or recording of a meeting, while commendable, are not a substitute for enabling the public to observe a meeting while it's happening. The city also failed to broadcast the portion of a meeting that took place after council came out of closed session. The Ombudsman noted that where council transacts business after a closed session, that portion of the meeting must be open to the public. Even when council is only reporting back to the public following a closed session, it is a best practice for the meeting to be open. The Ombudsman acknowledged that the city was concerned about the security of its closed sessions, but noted that municipalities could take steps, depending on the technology used, to protect the confidentiality of the closed meeting. This might mean providing separate meeting invites or call-in instructions for different parts of a meeting, or taking steps to ensure that live broadcasting capabilities are enabled or disabled at various points of the meeting as required. Minutes must be taken during both open and closed electronic meetings. In addition to recording minutes, maintaining a recording of your open and closed electronic meetings provides the most accurate and complete record. Audio or video recordings can assist greatly in the case of an investigation and enhance the public's confidence in the municipality's compliance with the open meeting rules. The public should be able to observe voting that takes place during an electronic meeting just as they would as if they were in council chambers. Municipalities should consider and provide the public with information on how delegations by members of the public, if permitted, will occur during electronic meetings. They should also update any procedures or policies necessary to reflect electronic meeting practices. Poor internet connectivity is an issue for municipalities that must broadcast electronic meetings live and for residents who wish to observe municipal government in progress. The township of Lanark Highlands told us that local internet was so unreliable, it decided to broadcast a meeting by teleconference instead. However, complainants told us that the quality of the teleconference was so poor, they could not follow the proceedings. We found that staff tested the technology ahead of time and had a member of staff listen to the meeting from outside council chambers to monitor quality. The call had to be restarted twice and there was feedback on the line, but the meeting did not violate the open meeting rules. Following the meeting, staff conducted more testing and consultation with members of the public, and council approved funding to upgrade its audio system to better support remote participation. When technical difficulties prevented the village of Westport from live broadcasting 2 meetings, it proceeded to hold the meetings without public access. The Ombudsman confirmed that the public was excluded from these meetings due to technical issues, and that as a result, they were improperly closed to the public. Posting recordings of the meetings after the fact, while a good practice, did not bring the village into compliance with the open meeting rules. Members of our office have met with senior officials in the Ministry of Municipal Affairs and Housing and the Ministry of Infrastructure to discuss limited broadband internet access and to support recent initiatives that would see major investment in improving internet access across Ontario. We understand that the government is putting resources in place to support municipalities interested in improving local broadband infrastructure. Even once the pandemic is over, ensuring that municipalities have sufficient technological capacity to support electronic meetings will improve the public's access to municipal decision-making. Even where there are technological challenges, the open meeting rules continue to apply. Municipalities should establish procedures to follow if there are technological issues during a meeting. These procedures should include the following: a way to monitor the public broadcast live stream so you know there's an issue, steps that a municipality must take if a meeting live stream is interrupted, for example, adjourning or recessing the meeting, ensuring there's a staff member available to respond to technological issues, and informing the public that the meeting has been adjourned or recessed, and providing notice when it is resumed. For example, in one case, we received a complaint about an electronic meeting held by the LGBTQ Advisory Committee for the City of Hamilton. For a meeting of the committee in October of last year, a staff liaison was working from home and using her home internet connection to host the committee's electronic meeting and stream the meeting on YouTube. During the meeting, the staff liaison's home Wi-Fi stopped working. As a result, the staff liaison dropped out of the electronic meeting and the YouTube live stream stopped working. Members of the public who were watching the meeting on YouTube abruptly dropped from the live stream. The staff liaison told our office that she assumed that as the host of the meeting, when she dropped out of the electronic meeting, the meeting had ended for all of the participants. The staff liaison texted the committee chair to inform him that her internet had stopped working. The committee chair acknowledged her text, but did not stop the meeting. It continued for 23 more minutes, with no one from the public able to observe it. As a result, we had to find that the public was excluded from the meeting, contrary to the Municipal Act. I know I've moved through most of this rather quickly. I encourage you to watch videos on our website that encapsulate the tips I've mentioned here, and to check out our Municipal Digest for examples of real cases we've dealt with. We update this continually. You can search our digest by dozens or even hundreds of keywords to help you filter and find the exact issue you're looking for. We also have a new edition of our Open Meeting Guide in the works. Electronic meeting tip cards will also be available in the coming days, and we have other tip cards currently available about other issues. While we can't provide legal advice ahead of a meeting, if you have questions, call us. We can help direct you to any existing resources or cases that might assist. In addition to our formal recommendations, we offer the Fairness by Design Guide to public sector bodies and leaders to help them build fairness into their processes and practices right from the ground up. This guide was developed by Canadian Ombudsman offices and is available on our website. In informing and assisting public sector bodies as they develop new policies and systems or assess existing ones, we emphasize that fairness is innate to human nature. If people feel that an organization will not treat them fairly, they will not fully engage with that organization, have trust in it, or accept its decisions. The results can be quite costly for an organization, as precious resources have to be directed to dealing with complaints, appeals, negative press, litigation, non-compliance, damage to reputation, or expressions of resistance. Our frontline staff often provide PDFs of this guide as they resolve complaints and deal with public sector bodies, and the Ombudsman has presented it to Deputy Ministers of the Ontario Government.